So I request Aditya to sort of set the ball rolling, and over to you, Aditya.
Am I audible? May I request cell phones to be put on silent, please? It's a pleasure and a privilege, sir, to be seated.
Thank you, sir. I'm really honored to be with all of you, and sensible of the honor of this invitation. I'm taking it from my 94th year at peace, and thank you very much for noticing me. Somebody asked what is the difference between a beautiful woman and a charming woman. Somebody said, a beautiful woman is one whom I notice. A charming woman is one who notices me. So you are a charming person, sir. Thank you.
If I can jog your memory, would you remember the factors that contributed to your decision to join the profession, to become a lawyer, to pursue legal education, to become a student of the law? Was it the family?
I seem to have had no option at all. My grandfather was a judge, and I still have his library, the British and Empire Digest, the first edition of Halsbury, successive editions, and enormously enriching atmosphere. And my father taught law. He taught philosophy in Maharaja's College earlier. Then he was asked to go to the West to train himself in philosophy and come back and work as a professor. The Vice Chancellor wrote to his father seeking his permission to travel abroad, since in those days it involved considerable braving of social opposition. And that beautiful letter was published by the Postal Department in Delhi in one of their exhibitions. A beautifully handwritten letter by the Vice Chancellor to my grandfather asking his permission, and promptly my grandfather refused. Then the Vice Chancellor told him, you have no future in the academics, you go back. Then he was married into my maternal grandfather's family, who was a judge. And he pushed him to the Madras Law College, where he studied along with Rajamanar and the others. And as destiny would have it, he came back to academics. He became the first principal of the Government Law College in Bangalore. He started the law faculty here. And of course, he died when he was hardly 59. And I think I had no option at all. It was as if, well, the journey has been a very interesting journey.
Sir, when you actually passed out, you have to work under a senior, and these days, of course, there are a lot of associates who work in the various law firms, but in those days, I am sure it was confined to litigation and not really corporate practice and other areas. So how did your journey as a junior start, under whom, and what kind of learning curve you were on?
See, my first teacher and my ideal was my own father. He spoke English and law so beautifully. And he wrote some in the Indian Philosophy Journal in 1956. In a publication, a fetch script in honor of Professor Wadia, A.R. Wadia, he contributed a piece which I later read, and his destiny was in the field of philosophy. but he became a lawyer by compulsion. And his career also ended in the way in which perhaps he might have desired as an academician. And in those days, law didn't have this kind of variety and dazzle and razzmatazz. It was a very narrow field. Law schools, even in England, never taught law in the strict sense. I've seen the Inns of Courts. In fact, I had this judge at several occasions to participate in the Indo-British Legal Forum. And there they teach the fundamentals. I think Narsappa is here. Perhaps he was also educated there. They teach the maxims, legal maxims. And the Inns of Courts take it further. Legal education is not very academic. In fact, even as lately as 10 years ago, a man with a degree in agriculture could become a solicitor after 2 years of conversion course. That's the kind of unacademic atmosphere in which law flourished there. But it was all in the real learning started in the chambers of the senior. When a senior talks to the client or the instructing counsel, the junior who watches the conversation, he enriches his storehouse of legal knowledge. When you see a good lawyer arguing a well-prepared brief before a good judge, that is legal education. In fact, that's perhaps I tell many of the seniors to send their juniors to a court and read the brief earlier and watch the arguments and write a shadow judgment themselves so that they would compare it with the judgment later. Nobody wants to take it seriously. It's a very, very serious business, and we are not attaching much importance to the academic side of law. You prepare something, the last minute the judges gulp it down, and this is not the way in which law will develop. Very soon, twilight will become darkness. We are in every field, you have a twilight. Imperceptibly, without your knowing, it merges into darkness. That's what I suspect will happen to the legal system itself. It will become irrelevant. And I was just telling my esteemed friend here that, for example, in 1945, in Los Alamos, the controlled nuclear fission was done. There's a very interesting story. It was done by, the whole work was done by an Italian physicist, Enrico Fermi, who worked under that famous physicist. And when they succeeded, they sent a coded message to the President of the United States, President Truman. The message read, the Italian navigator has reached the strange shore. The inhabitants are friendly. And that controlled nuclear fission, when the response of Einstein for that was everything changed. Humanity has to adopt new ways of thinking if it is to survive. It's a very sublime, very deep statement which we have not been able to understand the implication of. And humanity has to adopt new ways of thinking. And that occurred another 8 years later when the couple, Watson and Crick, broke into the then most seriously guarded secret of nature, the human genome. The decade of the genome, they spent $200 billion on that. And now unimaginable things are going to unfold themselves. And we are not ready for it. And least of all the legal system. And suddenly something will happen somehow, somewhere, somewhen, and then you find yourself in darkness. And there's no intensive thinking about it. My problem is not that we are not capable of thinking, but unfortunately, the legal system has got into a rut. I won't say gutter. I would say a rut. from which it's finding it difficult to come out. Difficult to come out. And one experience I must share with you, in 1991 or so, Mr. Palkiwala, who I happened to be one amongst his admirers, and he was very fond of me. Though all the cases he argued before me, I decided against him. And he never forgave me for that. But he said that the Indian Supreme Court would need 300 years to cleanse his mess. 300 years. And the Economist of London wrote a scathing indictment to the Indian Supreme Court. The judges met. I remember the way people were agitated. They were very uncharitable to Palkiwala. Then Chief Justice asked me, "What, you were silent?" I said, "Palkiwala is too big for me to comment. It is his love for this institution which made him say that. The intensity of that love expressed itself in that language. Instead of turning the searchlight inwards, you are focusing on him. You must thank him for that." That evening, the Chief Justice invited himself for a supper in my house, and then from tomorrow you will be in charge of the case law management. That was several years before I became the Chief Justice. It's a very interesting thing. We had 4,54,000 cases on that day. And I was not a management man. I went to Ahmedabad Institute of Management. Then help came to me in the form of an assistant registrar in the Tamil Nadu High Court. He had his own ideas of, he first said, "Sir, you don't have a rule in the, I perused the rules of procedure. You don't have a rule which will enable you to dismiss files which have been withdrawn from the court for correction and refiling." We found 33,000 cases of that kind, right from 1951 onwards. You simply didn't have a rule which said that you don't refile the papers within a period. Your court has the right to dismiss it. And the first bonus of a disposal was 33,000 cases in one go. Then there was one interesting case which was about 20,000 writ petitions had been filed. Very interesting question, very tricky question that turned upon the fundamental concept of what is an fraud on the Constitution. You can't apply a particular nomenclature to a subject matter of legislation, a nomenclature which will correspond with the grant, and then say, "I justify the legislation." For example, you say manufacturer, entry 84 of list 1 speaks of the duties of excise. And the judicial interpretation was that every manufacture involves a process, but every process is not manufacture. It must end in a product which is a commercially different thing. And there were 20,000 cases. Very interesting questions arose, and then every week this Attorney General would stand up before the court. I sat with the Chief Justice for quite a long time, and would plead with the Chief Justice, "Have a bench, you are losing thousands of crores by your revenue." And the Chief Justice said, "I don't have the bandwidth. I don't have the judge strength. There are 18,000 cases, and this seems to be a complicated matter." One day, being tired of the repeated requests of Parasharan, Chief asked me, "Look into that file and tell me how much time it might take." And a few days later, the Registrar General placed the file before me. I looked into it, and then a couple of days later, when we were going back from the court to the chambers, the chief asked me, "Did you look into it?" I said, I have done that. "What time will it take?" "Before you, it will be 2 minutes. Before me, it will be 1 minute." He said, "What kind of, why are you saying this. I said, look at this, whether it is manufactured or not under 84, you say, assume that it is not a process of, this process doesn't mean manufacture, you can't levy a tax, a duty, the difference between the concept of duty and a tax. Under 84, entry 84 list 1, but what escapes under 84 comes back under 97. Dillon's case in 72, they said that the residuary power goes to entry, residuary entry 97, and assume that it's not a process of manufacture. It still becomes amenable to legislation tax under 97. And when the matter was taken up, there was a very, very fine lawyer, very interesting, very humorous, his humor in court was extraordinary. I told the counsel, I was in the 5-judge bench. I said, look at what's your answer? He stood up and said, take it up next week, we'll perform the obsequies of the case. We'll perform the obsequies of the case. Of course, it was argued formally by lawyers from Bombay and Gujarat. Very interesting kind of things. And what I miss is young lawyers must read the brief, big constitutional cases that are scheduled for argument in the Supreme Court. Now it's possible with the permission of the court, the Chief Justice, by virtual participation, follow every argument, see the big lawyers making a lot of sound and fury, and then write your own judgment and compare it with that. It's a great preparation. That's how lawyers' minds are molded.
Thank you.
Sir, yes. You taking off from what you last said about young lawyers reading briefs and preparing, and also your comments on technology, there is a view that in the era of paper and pen and pencil and books, the retention and learning was far better than it is now when we use computers and digital resources. What is your view on, and what is your guidance for us on this?
I agree with that distinction. In the era of technology, you garbage in and garbage out. It is garbaging in, garbaging out. But in the traditional study of Sanskrit in the traditional schools, it is internalizing the information. Now, what you hear from one ear, you give it out to the other, is possible for a case, but it doesn't civilize you. Inside, the inner man is not civilized. And that's the difference between technology and knowledge. Technology has its benefits, its speed, its effectiveness. But learning and technological information, this is the difference between information and knowledge and wisdom. And this is information, and they rightly call it information technology. And it is not a civilizing influence, it is an anti-civilizing influence. It is a dehumanizing thing. I am not using that in a pejorative sense. It eliminates the participation of human element. It is not dehumanizing, it is not demonizing. It eliminates the participation of the human element in the process. That itself is a civilizational issue.
Thank you, sir.
When you were in the Karnataka High Court, when the judge of the Karnataka High Court, you must have, those days the bar and the bench relationship was somewhat different than what it is today. And I just wanted to recall some of the interesting kind of episodes.
See, there's a greater mutual respect. Today there's a mutual aversion. One is a critic of the other. And it's a personality issue. In those days, there is genuine respect for seniors who argued their briefs. I have seen some of the lawyers who were mesmerizing. There was one lawyer whom I don't know that any of you will recollect, you may not. There's one lawyer practicing on the criminal side. His name was Salem Narasimha Iyengar. And he came to argue a criminal appeal before a district judge, or in the High Court, I think. Justice Mallappa was the judge. My father asked me, go and watch him. It was a treat. Today you have knowledge of law and the rules. They had studied the classics. They had read Shakespeare, they had read Kalidasa, they had read the beautiful classics of the times. And that expresses itself unconsciously in the process of delivery of their diction and delivery. And I still remember when he was referring to the sentence, part of the judgment under appeal, he said, coming to the sentence, he said it is savage. The sentence was savage. I still remember the word used with such great effect and great effect on the mind of the judge. That's the kind of, this is the difference. Ladies and gentlemen, I would request you, I just recollect, there's one article with an American top lawyer who came to argue a matter in the House of Lords in those days. Now it has become the Supreme Court of England. He was a top corporate lawyer who came to argue a matter for the House of Lords. And the magical orality of the process in the English courts, in contrast with the written argument, written briefs of the American courts. He came and he found himself unequal to argue the matter for the House of Lords because of the orality of the matter. And he wrote, it's a very, I sat in the House of Lords with Lord Templeman when the matters were being heard. It's a great institution. And he said, the American top corporate lawyer wrote a piece in the Solicitor's Journal. I wish you pick it up and distribute it to your students. The title of that article is Gentlemen, Their Lordships. That's how the judges of the House of Lords are ushered into the courtroom. And he said 100 pages of neatly typed written brief is not equivalent to one meaningful shrug of shoulders of the Queen's Counsel in the court. That is the communication system. When the lawyers shrug out shoulders, convey so much to the judge that the lawyer has disapproved with the judge. And that's I think you must pick up that article and give it to the youngsters to read. Gentlemen, Their Lordships is titled, and he pays such beautiful compliment to the British system of the emphasizing the morality of the process. And there is another article which in the Law Quarterly Review, I remember, there is a committee constituted with the judges on either side of the Atlantic. I think Master of the Rolls in England presided over it. Lord Denning was there. 2 American Supreme Court judges were there. I think Brennan was one of the members. It is an article in the Law Quarterly Review. Hearing of appeals in England and America is the caption of that. Hearing of appeals in England and America. Please see that. And they say they pay great tribute to the English barristers, appellate barristers, in that article. I think these 2 articles, the youngsters, I'm not saying the elders should read that, but the youngsters must familiarize themselves with the technique of the court craft.
Sir, there is a well-publicized exchange of correspondence involving Justice M.C. Chagla, inviting him to the Supreme Court and explaining the incentives that federal court judges who then go to the Supreme Court would receive, and requesting him to come from the Bombay High Court to the Supreme Court. What was your experience and Justice Chagla consistently declined the invitation. What was your experience? What was the change that you saw from the High Court to the Supreme Court? What was new?
I'm deeply distressed about the way in which these things are handled. In fact, I was not a very big lawyer. I was not of course, by tradition, my father wouldn't pardon me if I was afraid of sitting with him in the dining table because he would ask me some question about a current issue and I would invariably fail to answer. And I could find the grimace in his mind, not on his face. The grimace in his mind, I could overhear his comments, internally not expressed. And that's how he asked me to read every one of the pre-counsel head notes of the pre-counsel cases. And unfortunately, I disappointed him. I went into, in those days, there's a great attraction for the IAS. I was just 21 when I took my law degree. I had my Hecate. I was marked lowest in the interview. And they sent me to the Indian police. And my father taunted me, now you have a great opportunity of either being a policeman or a gentleman. And of course, nobody would take up a policeman's job. He, at the end of the session in the court, he would compulsorily ask me to go on a holiday for a month to Uttarakhand. There was a client of his who had a nice guest house. And he would load the whole car with the pre-counsel decisions. He said, read the head notes of every case. See, between the 50s and 60s, that the precedent-ridden court. Then came the tools of legal control of government were fashioned by the second phase. The third phase found the execution of the implementation of their new tools. There are three phases of the Indian Supreme Court. First case, Sarkar, Vivian Bose. What sheer poetry, literature is something extraordinary. You can't match it. Nowhere in the world you get such beautiful ideas expressed in such a subtle form. Vivian Bose was a master of phrase and matched only by Lord Ratcliffe of Warneth. And he wrote a book, what is that, 52 Wreath Lectures, the magnificent book. In fact, I must have distributed at least 25 copies to my friends. That was the kind of excellence they had. Apart from law, there's an air of intellectual brilliance in the courtroom. Whenever a lawyer argued, you could see his erudition. And Newton Grant, speaking of that great Madras judge, who is that gentleman, he spoke of him, and he said in those days the courtroom didn't have an apron hiding their feet from the view of the lawyers. There's on a table and the feet were visible. Muthuswamy Iyer, Sir Muthuswamy Iyer. He says, Newton Grant speaking of him says, whenever a ticklish legal question was being argued, you could see his right toe pressing the left toe and the left toe pressing the right toe alternatively. And when we saw his left toe firmly pressed by the right toe, we knew that he had made his decision. Newton Grant, writing about him, he came to the court with a smarta wafer. Some people will carry that this thing. He would come. Newton Grant used that expression. He came to court with a smarta wafer. He called it a wafer.
Sir, these days, as Aditya was mentioning, people don't read much. And
don't read at all.
You have a fantastic recall of a number of books that you have read, not just law books, but also non-fiction, and you can recall from memory. Now, just wanted to ask you how important it is to continue the habit of reading, and is that is something which will help you to...
And of course, lawyers, tools of the trade of a lawyer are not the judgments or this thing, his own culture. His own culture, the width of his own range of his maturity. And he knows, in fact, if you had heard that lawyer who, I'll forget his name, skipping out, you could see the wealth of that inner wisdom coming out of serious study, the collection of the inner mass of inner wisdom, exuding, it's an aura. You could see the personality of the lawyer unfolding, and the court also. I don't know how to express my, I couldn't say, use the word anguish, my sense of concern about the superficiality of the acquaintance with the fundamental principles of our profession. It is not merely knowledge of case law, the beautiful flourish of the language. You see, if you see Chandrachud's judgments, senior Chandrachud, of course, junior also has the felicity of expression, but the senior Chandrachud was a master there. See how, I mean, it's amazing how they state the constitutional doctrine and method and philosophy through most perilous periods of time in Indian history. People don't understand. The House of Lords decides 60 cases a year. The American Supreme Court decides 130 cases a year. The Indian Supreme Court lists 1,000 cases every week. You don't understand that. You can't imagine the kind of the magnitude, the bulk that they carry. It's not an easy thing.
So related to the question is, and something that you touched upon earlier as well, the future of the legal profession. What corrective measures in your view need to be put in place both on the bench, the bar?
I tell you about the future of the courts. I had the Chancellor in my capacity as Chief Justice, Chancellor of the Law School University of Bangalore. We conferred a doctorate, honoris causa, on the Lord Chancellor. Michael Kirby was present on that occasion. There's an interesting conversation. Lord Chancellor asked Michael Kirby, "What do you think of the future of the courts?" Is the question you asked me. Kirby's answer was, "I am so glad that the Lord Chancellor thinks they have a future at all."
What corrective measures can be put in place?
Huh?
What corrective measures can be, what course correction can be adopted?
I somehow feel very pessimistic about the attitude the lawyers and judges have towards the problem. If you don't know the problem, you don't know the solution. The problem is the lawyer and the judges themselves. And you have 70, at least 70% of the work of the courts are not judicial. They are administrative work. You are quite inadept at handling administration. And if you don't have systems men to handle that, you just say a matrimonial case must ideally be over in 4 months or 6 months. A property possession, ejectment and eviction are two different ideas. It's a case of possession of property and the base of title, say 1 year or 2 years, whatever it is. You prescribe it. Give it to systems men. They will plan it for you. Harish is here. He will tell you how we have intensely, passionately thought about this issue. And I gave a full-fledged idea how a typical pilot project could be done in a district and test the veracity of this method. Nobody is prepared to do that. The biggest enemy, see, there's one beautiful story, everybody must read that. Blackjack Bargainer is about a lawyer. It's about a lawyer. It's a beautiful story of, they said, the most disreputable feature in Yancy Gori's law office was Gori himself. He said that, and then he unfolds a beautiful, I don't know how to share my anguish that we have spent our lifetime in trinkets and quibbles and the small things, missing out the bigger picture of life. And lawyers in those days were respected. Everybody would stand up. Today, everybody will look askance. When you said lawyers round table, I thought lawyers round tripping of cases.
So there are so many matters. Some of them are, questions of law and questions of fact. When it comes to a case which is predominantly on facts, for example, the New Deal regulations of Roosevelt, and some of them were challenged. And one of the regulations that was challenged was hiring of women in bakeries beyond 5 o'clock in the evening, and then the judge.
Lochner.
Yeah.
Lochner and those New Deal, see, they're the heydays of the due process.
Yes.
Heydays of the due process. And that was very interesting. In fact, Edwin Corwin, in his beautiful book, Constitution, What It Means Today, has a chapter called The Demise of the Due Process. Demise of the due process. And this is, for example, a partial and shadowy reflection of what Junior Nariman said, manifest arbitrariness. This reflection of the old doctrine in Lochner and those cases in which bakery hours were restricted. Paper currency was prevented because their own conception of the law on the matter. Bakery hours, it interfered with the freedom of contract. Fixing of limited hours in bakery, when in a furnace you work there and you can't work more than 8 hours. American Supreme Court struck it down on the ground that it interfered with the freedom of contract. This is exactly the reflection of the two philosophies on either side of the Atlantic. Both swear by the Bible. In the European side, St. Augustine said possession of property is sin, and the basis of the Bible. And the other side, the American Constitution said pursuit of happiness is the assurance of the Bible, and there the government is only an arbitrator. The American government is conceived principally as an arbitrator.
So there are, people say these days there are 3 innings a legal professional plays. One is as a lawyer, the second as a judge, and third as an arbitrator. Why have you not played the 3rd innings?
You see, I'll tell you why. See, one Chief Justice telephoned to me immediately after some time. I want you to arbitrate this matter. I fixed a fee of several crores, he mentioned. I told him, Chief, I am not doing any arbitration. He said, I request you to do it. I told him, if you request me, take off the fee part of it, don't mark a brief fee in the brief. Give me a small chamber in the Supreme Court, I'll come and complete the work and come back. He blurted out immediately, no, it will become a precedent, everybody will ask for some place in the Supreme Court. I said, everybody aspires for a place in the Supreme Court, all right, but there is a limited courtrooms, but I don't want a courtroom. Then somehow the matter ended. Then in those days, an award had to be made a rule of the court. The present dispensation was not there. And usual complaint, the magical words were misconduct. Award was challenged, and a Chief Justice of India being accused of misconduct, though it is a legal concept, not a physical, pejorative sense of misconduct in the sense that he misbehaved with a woman or some such thing. That's not the idea. It's a legal concept. But then I thought a Chief Justice being exposed to a civil court, a civil judge before whom a lawyer says that this Chief Justice misconducted himself. The law has changed now. But in those days, I thought at least the Chief Justice must be sensitive about the semantic abuse that is potential in the language of attack of an award.
Any question from the floor, particularly the juniors? If you want to ask Justice MNV any question, please, we'll pass the mic. Yes, please.
We'll bring the mic across.
We'll get the mic, please.
Okay, thank you. First of all, it's such a pleasure to meet you in person finally, and thanks Prasanna for organizing this. I'm Kavita Gupta, so I'm compliance officer for SAP.
Kavita Gupta.
Yeah, I work for an IT company, though, as a legal counsel. But I practiced in High Court for 4 years.
Gracious lady, you're too fast for me.
Okay, I'll go slow.
I'm a little...
okay, I'll go a bit... okay.
Please do come. Tell me.
Okay, so I wanted to know from you about your views on judicial review, judicial lawmaking, activism, whatever name they give. You know, we see like there's a lot of change, as a colleague mentioned, you know, about the technology that has come into place. You know, we have, unfortunately, we do not have laws while we are seeing new techs coming into place. Earlier we were in Web 2.0, now we are talking about metaverse, we are talking about artificial intelligence. So this is where I wanted to know more about what's your view about judicial lawmaking and when it comes to...
Thank you.
Thank you. You are an aggressive person. I tell you, the world is poised for the biggest physical change that could have ever happened in the history of civilization. Civilization has always followed the influence of energy, sources of energy, animal labor, human labor, petroleum, steam power. Steam power changed the whole thing. In fact, there's a great story about, you must see that Peter Drucker, how internet, he compares the internet to the railroad revolution, what happened there, and then how everything ended. For example, a company which was making steam locomotive engines for 100 years, I think Baldwin Locomotive Company, they said we are making steam engines for 100 years, who could stop us? Next year they announced their bankruptcy because diesel power came in. And then electricity, nuclear, steam power, electricity, nuclear power. And now what is the whole humanity is governed by the sources of energy. And we must understand what the power of the mind is the source of energy today. The kind of changes that are occurring are fantastic. And I was telling Professor Balakrishnan, for example, you have the genome revolution. Today, all these big diagnostic machines, the MRI machines, have to be sold away by weight to the Gujriwala. The diagnostic tools are 1 drop of blood, 1 drop of urine, and 1 pick of the earwax. That will tell you whatever diseases you have today and whatever diseases you are going to get from time to time, and when you end, it will give you the prediction. Watson and Crick, and one of them said, the highest act of friendship in science is the honest criticism. Highest act of friendship in science is honest criticism. The highest act of friendship in law is honest criticism today. What is the system you are going to huddle yourself up with? It is going to explosive. The whole things must change. The range of the mind must change. And the range of the mind comes out of good reading and good thoughts and good contemplation. And this is where the young minds are very sharp. As she said, look at this, what is happening to metaverse and all that. It's going to be the most dangerous kind of thing. You know, holographic imaging. You press a button, sooner or later, the technology is already there, but it will be available to you very soon. You press the button, the person who wants to talk appears to be in a three-dimensional figure. You can touch him. The science of haptics says you can shake hands with him. And shaking hands, when the kind of relationship between a woman and a man cannot end merely with shaking of hands. What kind of potential it has for the danger of the morality of society? Nobody has imagined it. And today, the biggest business in Japan is something which is unmentionable.
I think now we can have an avatar also for Justice Venkatachaliah.
Yes, anyone? Yep. Yes, please.
Siddhartha.
So just a short question.
Will you come here, Siddha?
No, I can speak.
No, he can hear me if you come here.
Since you mentioned the senior justice Chandrachud, I recall from my law school days, in the last paragraph of his judgment in Keshavananda Bharati, he wrote to this effect: as I see the judgments of my brother judges coming, I ask the question, was it worth it? Was it worth it?
It is. You see, the time spent, time wasted in talking to each other is the very essence of democracy. The time wasted in talking to each other is the very essence of democracy. This is the sentence I wrote in Justice Anand's book on Kashmir Constitution. And I opened it with Marshall and Moody's statement, all executive power vests with the Queen. He says, Marshall and Moody in some problems with the Constitution, they're beautiful books, sir. I think juniors must read that. He says, all executive powers vest with the Queen. It's a very interesting and impressive statement, but there's just one small mistake in it, that it is exactly the opposite of what the reality is. And Article 52 of the Indian Constitution says all the political executive power will vest with the President. And Rajendra Prasad interpreted it to mean literally, I am not the British Queen. This is the difference between Nehru and Rajendra Prasad in the initial stages of their debate. And recently, one president, when the government, the central government, it is in a writing of a former cabinet secretary of I think Prabhat Kumar was the cabinet secretary. In one of his writings, he says, one of the presidents asked him, this is a caretaker government. People talk of caretaker government. Chandrachud's judgment says in the Supreme Court that no idea of a caretaker government, it's a responsible, correct constitutional government. After you have lost your majority, you are asked to continue till the next election is over. And you are not a caretaker government. There is a wrong impression. The Supreme Court has said this is a wrong impression, this is a correct government. And one president asked the cabinet secretary, this is a caretaker government, there is no majority, route the files to me directly. The cabinet secretary said no. Cabinet secretary said no, this is not the law. President, like the British Queen, and then I think a beautiful fluvial metaphor of Krishna. The Rashtrapati Bhavan is not the halfway house between the White House and the Buckingham Palace. It is not the Potomac, but the Thames that fertilizes the flow of the Yamuna. the Thames that fertilizes the flow of the Yamuna.
Yes, please.
There's a question.
I think I'm delaying their lunch.
Yeah, another 5 minutes.
So first of all, thank you for an excellent address. You mentioned that a lot of things in the legal industry and the legal fraternity needs to change. What role do you think technology will play in this, and what would you like to see? What's your wish list?
Yes, lady, you have a British English accent. I am not able to follow it. Can you clarify your question?
Right.
Come nearer. I think I'll hear you personally.
She was asking what role technology will play in revolutionizing the profession.
So my question was, you mentioned that lawyers and the legal fraternity need to adopt to change. What
Protection
role do you think technology will play in that?
What will be the role of technology in the progression of the profession or the revolutionizing of the profession?
Thank you.
Revolutions are two ways. They produce good and produce bad also. And I foresee both in this. The technology will enrich you, all this kind of searching for but the touch of the book, the cultural influence of the touch of a good book, technology won't give you. And if you think that what I'm talking is nonsense, well, then so be it. But I always enjoyed handling a book. But sticking on to a book is not the thing. For information, go to technology. For wisdom, touch the book.
Mr. Nandakumar here.
So thank you for that very inspiring talk.
My goodness, thank you very much.
I am going to ask you something I'm conscious that you might decline to answer, but could you please share with us the secret of your unbelievable memory?
I want somebody to give me a small pill to get rid of my memory. Sir, I want to appeal to youngsters. Life is a beautiful thing. It's beautiful, colorful. Don't spoil it with contamination of bad aspirations and bad wishes and this thing. A pure life is a great reward, and a lawyer's life is a great excitement. I tell you, there is no profession, personally speaking, no profession as exciting and as inspiring as beneficial to society as that of a lawyer. And I must have handled thousands of cases, all petty matters, not very big ones. The one in which I had the honor of Mr. A.K. Sen, as General Secretary of the Indian National Congress, came to my chambers with a client, with a congressman who had lost his election. The Supreme Court had declared him to be a Christian and unseated him from a reserved constituency. That's a prestigious constituency for the Congress party in the Karnataka state. And Mr. A.K. Sen was then the General Secretary. He was a very eminent lawyer. I think amongst the lawyers, I rate him for his knowledge the topmost. The present day top lawyer is here, Sen was here. That was the kind of man. And then it was a case in which the Supreme Court had declared a particular person to be a Christian and ineligible to contest from the reserved constituency. That's a famous case, and I conducted the trial. And I won, and we had a process of reconversion and acceptance. The question was, well, if a Christian can become a Hindu, but how do they acquire the caste of, his original caste of scheduled caste? How do they acquire it? This question was a very interesting question, and the judge, in fact, I want to tell you, he was a very fine judge, a Christian judge. He was a sportsman. Wherever he was a judicial officer, he had started a cricket team with the bar and the bench. Justice Narona, a very, very noble man. And after the judgment was rendered, that it's a bit of a sensation in some political this thing. That night, the judge came to my house. I was astounded. I said, Judge Saab, he said, I came here to congratulate you for the brilliant performance as a cross-examiner. I told him this is what I learned from my father. The art of cross-examination is gone. It is the witness who cross-examines the lawyer now.
Thank you. Is there anyone else? Okay.
One last
question, yes.
Thanks for allowing it. Thank you, sir, for this, and your energy is always inspiring. I just had a question on, you mentioned legal contemplation and you spoke about internalization. Now, as we all know that technology has advanced so much that you have distractions all around and everything is more fast-paced. So what are your thoughts on the importance of contemplation and internalization in an age where everything is equally also very easily accessible?
What is it?
You think when everything is easily accessible, how important is internalization and contemplation?
One is for the body, the other is for the soul. And if you think that information technology can give you salvation, I think you have to ask yourself another question, whether life is worth living at all. See, the experience of art, if you are not able to enjoy music, any amount of technology which you have in your head will take you nowhere. It will make you a successful man, not a wise man, not a worthy man. And the dehumanizing thing, as I said, it's not in a pejorative sense that is demonizing it, but it will eliminate the human element. The pursuit of a pursuit of a goal is as much exciting in the process than in the achievement of the possession of the result. It is not, sometimes a sport. Your gaming app will give you a beautiful sport and a victory. Do you think you have won a match? You have a gaming thing and then you play on the machine and then you win the bout. Do you think you have achieved a success in your football field or the baseball field? This is the difference.
Thank you. Thank you, ladies and gentlemen, and that has been a very interesting conversation, and I thank Justice MN Venkatachaliah for
Thank you, sir. Thank you, sir. Thank you. I'm going to open a shop with this or what?
I will not be able to hand it over to you. If you can accept it,
My goodness.
if you can symbolically accept it, I will hand it to one.
Well, thank you, sir. Thank you.
Thank
I'd
you.
like to open a shop with this. Oh, come on. Thank you.
and the AZB and partners who have hosted this 100th LRT, milestone LRT. And I have Aditya's permission to say that he will be hosting the 125th.
And the 150th.
And the 150th. Thank you. Thank you very much. And please remember that IDIA desk is outside, and please contribute generously to the objectives and the kind of program that IDIA actually, please go ahead and bon appetit. Have a great lunch.